The topic is, what is a divisional patent? I'm going to explain what a divisional patent is and when you use it. Before I forget, if you find value in this video, we read every comment and base our future videos on questions that you have. And we love to hear how our videos help you to understand this complicated topic. Now, what is a divisional patent? So first of all, let's talk about what goes into a patent application. So a patent application really has two main parts. There's the disclosure and there's the claims. The disclosure is the complete description of what the invention is, from A to Z, all of the detail. On average, it might be around 20 pages of description. Sometimes it's as much as 100 to 200 pages. But that's where you describe every single detail of the invention. But then you also have the claims. And in the claims, we point to what the unique elements are, what the unique combination of elements are that we're going to claim is our invention. And we're going to claim that other people can't do through this patent. And so, for example, we've described A to Z in the disclosure, but we may claim that B, C, and D put together is unique and should be patentable. And that's what we're claiming. But sometimes in the claims, we might claim B, C, and D, and we might also claim B, C, and F as a possible patentable combination. Now, when it gets examined by the patent office, the patent examiner may say, wait a second, there's two different inventions here. B, C, and D and B, C, and F are two unique inventions. You need to pick one. And that's called a restriction requirement. So when the patent office issues a restriction requirement, basically they're saying more than one invention is present. You need to pick one to proceed with now. And we do. We respond with what's known as an election, where we pick the version that we want to pursue right now. And so we might pick, for example, B, C, and D. And the examiner will then continue to examine that combination. But we might say, well, wait a second, we also want B, C, and F. So then what we do is we file a divisional application, which then has the claims that go to B, C, and F. So the divisional application is essentially a later application that we file to pursue that other invention that the patent office examiner didn't allow us to contain or to be reviewed in the original application. And by the way, the original application we often call a parent application. So we have a parent application where we're pursuing B, C, and D. And then separately, we file this divisional to file B, C, and F. And when can we file a divisional application? We can file it at any point while the patent application is pending. So immediately after answering that restriction and filing that election, we might say, well, let's just file a divisional to pursue B, C, and F. Or we can put it off for a bit. And if we put it off, though, we need to do it while the application is still pending. So while that parent application is moving through the process until the point at which we give up on it and it becomes abandoned. Let's say B, C, and D is not patentable and we can't continue with that. And then before that application is abandoned, we must file that divisional or we'd lose the right to do so. Also, if B, C, and D is approved, that parent application is approved, we need to file the divisional application before they actually issue it into a patent. So you can file a divisional application at any point while the patent application is pending. Now, sometimes we'll get a restriction in not only a utility application, which is what I've just been describing with disclosure and claims, right? That's typically a utility application, but also a design application. Sometimes in a design application, you have more than one version of the design. So now a design application is for the physical appearance of an object, but just for that look. And so maybe you might file an application of this water bottle, one that has all of these features and ridges, and one that doesn't have these ridges. So you file two sets of drawings in it. Sometimes that will be allowable, but sometimes an examiner will issue a restriction and say, two inventions, you have to pick one. So in a design application, there might also be a divisional, in which case you then file that other set of drawings that you didn't pursue in the first application. So one of the main advantages of filing a divisional application is that you can get patent protection on an invention that was not chosen in your parent application. And so it gives you the ability to maximize your economic benefit from the application, possibly leads you towards two patents. And of course, this helps you to create a patent portfolio. And patent portfolios are very attractive to new investors. Patent portfolios are more difficult to overcome by a potential infringer, by a potential copycat. And so they increase the value in what you have, and of course then increase the value to investors. And again, a divisional, since you're filing it while the application is pending, it could maintain the pendency of the application family. And there are various benefits to doing that. A lot of times when you get an initial patent, you're happy, you've got the patent, it's been granted, but sometimes there are other inventions in there. Like maybe in addition to B, C, and F and B, C, and D, there is the combination of C, E, and J, which is a unique combination that can lead to its own patent. But your ability to file that application, your option to file that application, is only while the application is pending. So filing that divisional application helps to maintain the pendency of the application family. It keeps it alive, which gives you the option to potentially file other applications, such as continuations and continuations in part, which you'll find me talking about in other videos. In general, the cost of filing a divisional application is much less than the cost of filing that original non-provisional application, filing that original utility application, in other words, because there's not a lot that goes into getting the application ready to be filed. You're essentially doing a little bit of surgery on the claims and refiling the original disclosure. So it's relatively inexpensive to file a divisional application. And of course, you're going to have to pay another government filing fee for filing that because it is another utility application. So what should you keep in mind with regard to divisionals? Well, first of all, you only file them when necessary. Sometimes, actually very often, an examiner will allow you to have that B, C, and D and B, C, and F combination in the same patent application. Sometimes you have what's called apparatus claims and method claims in the same application, and the examiner allows it. Other times they'll restrict it and say you have to pick one, and then you'll file the other set in the divisional application. So in this respect, you follow the lead of the patent office with regard to only doing it when it's necessary, only doing it when it gets restricted. And of course, there are jurisdictional differences. So if you're talking about a utility application in Europe, a European application, or a Japanese application, there are different procedures that you might want to keep in mind. I'm speaking mainly to the process in the United States and the processing of United States patent application. But in general, that's what a divisional patent application is, and that's when you use it. If you're a business focused and looking to build a patent portfolio to increase your company valuation, go to goldsteinpatentlaw.com/apply and schedule your complimentary patent portfolio strategy session with one of our expert business strategists.